Today's topic is method of comparison of handwritten and signature. Method of comparison of handwritten and signature. Before we move on, let's talk about a preliminary procedure. The first thing you do is to determine if the material is of good quality and contain enough characteristics of handwriting to be identifiable. So you look at the quality of the material given to you, if it is handwritten, look at the disputed handwritten and the one that is the standard that you want to use, the known sample that you want to use. You look at the two. If they are of good quality, then you go ahead. The same thing if it is if it is a signature, you look at the quality. If the quality is of good quality, then you have to proceed. Then after that, you make sure you get enough quantity. Enough quantity. To, if possible, make sure you examine the original. But there are some cases in which it is not possible to lay hand on the original. In that situation, you have to make use of a photocopy. But that photocopy must be a clean and very clear photocopy. If you are using photocopy, it should not be multi-generation photocopy, as this might have lost some vital pieces of information. Use this checklist. Use this checklist. The first thing to consider is if the material is a genuine copy. The copy given to you may be clean, may be clear, but it is possible that it's not a genuine copy. So you have to make sure that it is a genuine copy. How do you do that? You have to collect some sample from reliable sources. For example, then another thing you look at, you check if the document has abrasion or not, or whether there's a sign of erasure or lack of continuity. Able to, if there's any abrasion or a sign of erasure, then that must be noted. Then another thing you look out for is if there is any indentation. So indentation may be a sign of forgery. So you look out for that one. Then lastly, you look at it, you check if there's more type of one ink that was used in the preparation of the document. Is there more than one type of ink used in the preparation of the document? This one must be, you have to take note of that. Then you get details. You get details as to the circumstances of the document in question. For example, perhaps the document was placed on a rough place while creating it, while written on it, or perhaps you get the detail of the condition of the alleged writer. Probably the alleged writer was drunk while he was written or signing the document, or probably the alleged writer was sick, or he was already under drug. So all these things must be written down, you have to take note of all this, because these are the things that are capable of affecting the handwriting of an individual. Then next is the golden rule. Says that you must collect similar samples. In forensic, there's a law known as law of comparison. This law emphasizes the need to collect samples that are similar. That is why in question document examination, if you are comparing handwriting, you can only compare handwriting or that has that has a similar letters. For example, you cannot compare Aza to Olomu because they do not have any alphabet that are similar. So you have to collect similar samples, and cursive should be compared with cursive, handprint with handprint, handprinting with handprinting, ink signatures with ink signatures, upper case with upper case and lower case with lower case, line paper with line paper. So tell the subject to write on similar paper to the question document in question. Exemplar is a document that is known to be written by a particular person, that is authentic. We know this is authentic, we know this is genuine, and it's from the right source. So this kind of a document is used as exemplar. We call it exemplar or standard. It is a known sample that we call standard or exemplar. So the exemplars or standards are what we use as like a template for the disputed. So we compare the exemplar with that of disputed. Now, there are two types of exemplars. The first one is collected, and the other one is requested. Collected and requested. Collected and requested. The collected samples or exemplars, the collected exemplars are those exemplars that we retrieve from the archive. They are existing, they are already existing, and we use them mostly for situation in which the original writer, the writer or the creator is already dead. Example is when you have a will and there's a dispute on the will, then we cannot ask the dead man to write or to sign on a paper so that you can use it as an exemplar. All you will need to do is to go to the archive, maybe his office, the former office, the house, or anywhere where we can lay our hand on the former, on those things, those documents that he has created before his demise, or this document that he has signed before his demise. It may be document like a note to bank, letter to an organization, or identity card or identity documents. All these can be used. All these can be used as exemplars or standards, or because they are known samples. Because they are known samples. So the collected samples are mostly used in a situation where the writer or the creator of the document is already late, is already dead. But there's another one called requested sample or requested exemplar. So a requested exemplar is that kind of exemplar that we ask the alleged writer to write, because he's still alive. So you can demand that he write to write some things down so that you can examine and use it to examine, use it as a standard, use it as a template, use it as exemplar, as a no sample to be compared with the disputed handwritten or signature. And there are methods of obtaining this kind of exemplar from the alleged writer. One method is by asking the exemplar. One method is by asking the suspect to write. One method is by dictating to the alleged writer, we dictate to him the content of the disputed document. We dictate to him and we write him to copy. As we are dictating, then he is also writing it down. But we must prevent him from seeing the content of what we are dictating to him. So after a period, just have the suspect do some free writing to loosen up. Then dictate the material at a reasonable speed. Do not give any help with spelling or punctuation. Have the suspect sign and date the sample. Take the sample and set it aside out of view, out of his view. Let there be general conversation so that if the suspect had been disguising his handwriting, it will be difficult for the suspect to go back to the disguising state. So ask the suspect to repeat the task. This is a good time to request that the suspect use a different paper or written instrument if appropriate. Then dictate a bit faster the second time. More repetitions may or may not be needed. Then it may be important to request that the subject write in printed or cursive form depending on the content of the disputed document. So it may also be necessary to ask him to write with unaccustomed hand. Maybe he had been you be dictated to him and he has been written using right hand. Then this time around, you may ask him to use his left hand to write, because there are some people that are ambidextrous, that is, they can write with two hands. So if you are examining a handwriting or signature from the accustomed hand, from the right hand, then you may be mistaken, because what is if you are examining the handwriting of people that can write with their two hands, the characteristic that is going to be introduced into the right hand is going to be different from that of the left hand side. From the right hand, from the left hand. So if it is necessary, ask him to use the left hand to write also. So after this, use questionnaire. Use a questionnaire to identify any circumstances that could affect the rating, such as drug abuse, illness, or injury. Drug abuse, as we have said in the previous classes, will affect handwriting or signature. We have illness also will affect it. Also injury, maybe injury to hand, to the wrist, will also affect written. And also age. So when you use questionnaire will help you to get all this detail. I'm going to send a questionnaire to you, a sample of a questionnaire, so that you can use it. You can be using it to do such kind of a work. After this, the handwritten material should be enlarged to about 200% on A4 paper before the comparison. And this enlargement can be done using photocopier machine, clean photocopier machine. The comparison can also be done using computer software such as Adobe Photoshop or microscope. The extraneous part should be removed. Then you concentrate on the part that is needful. And while doing this, you must not forget about the scientific principles that you have learned in the previous classes. So this will help you greatly. Let's move ahead. There are cases in which no exemplars are needed. Cases in which no exemplars are needed to prove spuriousness. To prove spuriousness. Number one, no one can write their signature exactly the same way twice. Therefore, identical signatures on a document, maybe you have like two, three, 4 pages, and the first you are on the first page you have a signature, maybe on the second page or third page or the last page you have another signature of the same person, and you confirm that both the two signatures are exactly alike, 100% the same, 100% similar, then that is that in that kind of situation you don't need exemplars. You don't need any exemplar to confirm that these signatures are spurious, are not genuine. So this can be in form of simulation. That is, what I'm trying to say is that identical signatures are generally evidence of no genuineness, and this can be in form of simulation, cut and paste, or scanned signature. Though there are cases where, as we discussed in some previous lecture, that there are cases where you can have signatures that are scanned into the system and they are being used or using stamp. In that kind of situation, they are scientifically, you can say they are not genuine, but legally they are genuine, because in that kind of situation, the user of that signature might have gotten permission from the writer, I mean from the owner of the signature, to be used. Another case in which no exemplar is needed is writing of the impaired, visually impaired or illiterate can be identified as spurious if the questioned written exceeds the ability of the known writer. For example, a high skill level signature of an impaired or visually impaired individual can be rejected without comparison document. Now, thirdly, document that contain indication of tracing can be identified without known signatures. Evidence of tracing, of course, the signature will be that evidence of tracing will be a ghost line along the signature line or residue of pencil or carbon on the paper. So if you see all this, maybe carbon or the carbon from the carbon paper, or residue of pencil, or a ghost line, then you can be assured that you are dealing with a non-genuine signature. Let's move forward. In question document examination, elimination is when you have all the evidence that is needed for you to say that a particular writer, an alleged writer, is not the writer of the document, is not the creator of the document. Therefore, you are saying that there's the possibility of him creating the document is low or is nil. In that kind of situation, you are eliminating him as the writer. So that is elimination. And education is when the possibility of the alleged writer creating the document is high, or the possibility is 1. So in that kind of a situation, you are saying that you are identifying the alleged writer as the writer or the creator of the document. And there's something that is very important when we are eliminating, and that is what we call fundamental differences. Any fundamental, unexplainable analytic characteristics that is not part of the master pattern indicate a different writer. You understand what I mean by pattern writer, as we discussed in the previous lecture. Differences must be fundamental. When we say differences, when you are talking about difference between the disputed and the exemplar, that fundamental must be, that difference or those differences must be fundamental. Explanation for differences include accidental or deliberate disguise. Outside factors such as health problem and aging also affect handwriting and can be the reason for significant differences between written samples. But a fundamental difference is an irreconcilable difference. Fundamental differences in handwriting that are significant include differences in the in line quality, pressure patterns, method of construction of letters and words, or subtle subconscious handwriting characteristics. So differences in letter forms are also significant but not necessarily fundamental differences. So all this must be considered. The fundamental difference must be considered before we can say the two documents are not from the same person. So uh, when there's no differences, where there's no fundamental differences between two handwriting, you can identify the writer. You can use identification, that is identification can be done. But when there are fundamental differences, then there's going to that will lead us to elimination of the alleged writer, of the accused. Yeah. If you look at the screen, you can see the schematic representation of the examination and comparison of handwriting or signature. Schematic representation of the examination and comparison of handwriting. The first thing is to assess the quality and quantity of handwriting for comparison. This one applies to both questioned and the unknown. So you look at the quality of both of them. If the standard, that is the exemplar, the known sample, if the quality is poor, if it is bad, if you cannot see part of them, if there are no characteristics to be compared with the question, then you drop it. If you look at the questioned, if there are no enough characteristics to be compared with the sample, with a known sample, then you drop it. So the assessment of the quality and quantity of the handwriting for comparison applies to both questioned and the known. So if the answer is yes, if the quality and the quantity are okay, then you move ahead. You ask another question. Are the two pieces of handwriting comparable? For example, as I said it the other time, you can't compare answers. You can't compare answers to Olomu because there are no letters that are the same and that are similar there. No letters that are similar. On answers, you don't have O, whereas you have O in Olomu. In Olomu, you have L. You don't have L in answer. In answer, you have A, or you have said. You don't have said in Olomu. So both of them are not the same. So there's no way you can compare the two together, because the law of comparison in forensic states that, or emphasizes that, two samples two samples that are comparable must be collected. Two samples that are comparable must be collected. So if the answer to the fact that they are comparable is yes, then you go further and do your examination. Then what do? You go to assessment of the general characteristics. But if you go to, before you go to that one, to the third step, if the answer is no, then you have to stop. You have to look at any other, if there's any other thing that is available, handwritten that is available. If not, you stop that one. Now let's go to the third step. This third step, after you might have confirmed that the two pieces of handwriting are comparable, that is the known sample that we call exemplar or standard, and the disputed, if both are comparable, then you move on to assessment of the general characteristics of handwriting for comparison. That is, you look at all the characteristics that are present uh, in the questioned, one after the other. You note the characteristics down. You you assess them and note them down one after the other. If you are using manner, maybe you are doing on paper, then you write them down one after the other. But if you are using your computer, you uh, as you are identify those areas where there are similarities, you use your arrow to point to that part, and you use your computer to write whatever you examine there, you identify there, you write it. Then later you explain it on the next page or down. You do the explanation so that whosoever read it may be able to understand what you analyze there. As you do it for question document, then you do the same thing for the exemplar, for the standard, for the known sample. Then after that one, you go to the next step, which is examination in detail of a piece of handwriting. The first one, as we said, that the last one was general examination, but now you go into detail. You go deeper. That one is deeper into detail of the examination. For example, the last one, you examine things like a method of construction. But by the time you get to examination in detail, then you also consider some subtle details, like where he used to put his comma, how he used to put his comma, where he used to put his punctuation mark, or his dot, how he put his dot on I or on T. So those things also. After that one, then you go to the next step. The next step is to ask a question from yourself: has all the comparable handwriting been examined in detail? If no, if the answer is no, then you go back and do it and re-examine. So when you look at it and the answer is yes, if all the comparable handwriting has been examined, then you go into the next step. You go to the next step, that by going into detail examination of the handwriting, you go to do the detail of, you go for, just as you do for questioned, you also do the same thing for the exemplar, Then after that one, you go back and make sure that what you have done is correct before you now reach the final stage, which is conclusions and report writing. The report writing will be one of the last topic. That we are going to discuss. So let's leave that one today. Now, care and preservation of question document. Make sure you do not carry question document in with other materials in the wallet. Do not carry question document with other materials in a wallet. If not, if you do so, you might introduce some things that were not there into the document. For example, if you are carrying question document with other materials like pen inside the same wallet, then it's possible that pen give marks and put punctuation mark, put dots where they are not supposed to appear, and that one may lead to error, may increase the error rate. Then another reason why it should not be question document should not be put in the same wallet with other materials is that there are some material that may contain chemical that may destroy some characteristics of handwriting or signature. So the best thing is to make sure that if you have a question document, let that question document be inside an envelope that is meant for that purpose. Then do not make markings, erase or impress rubber stamp on the question document, because all those things will change whatever you have there. If there's anything you want to write or you want to make a remark, do not write it on the question document. Do not try as much as possible that if you are, maybe you want to rubber stamp any document, do not place it on the question document, and make sure you don't erase anything on it. Then thirdly, keep the document unfolded in prospective envelopes. Make sure that the question document is not folded. Just put it inside the question inside the envelope that is meant for it. And fourthly, the question document must be handled with cotton glove to prevent fingerprint being deposited on it. This is where we are going to stop today. I will send all the material to you. Please make sure you download them, especially those forms, the questionnaire. Make sure you download them. You will need them later. Yeah, see you in the next class.